Good afternoon, everyone. So 1 o'clock. We said we were going to start again at 1. Executive Director Nevitt, does it look like we have quorum, or should I take a roll call vote?
It's hard to tell, so I would suggest we do a roll call.
Okay. Governor Abell. He said he was going to dial back in. Governor Adwale. Governor Angelville. Governor Boyd.
Here.
Governor Clark.
Here.
Governor Couch.
Here.
Governor Dresden. Governor Higginson.
Present.
Governor McBride. Governor Peterson. Governor Pertzer.
Here.
Governor Sayani. Governor Stevens.
Here.
Governor Williams-Ruth.
Here.
During the roll call, I admitted a few phone numbers, so you might want to go back through the folks that
Sure.
say those.
Governor Abell, are you here?
Yes, I'm here, Mr. President. Thank you.
Governor Adwale, are you here? Governor Angelville, are you here? Governor Higginson is here. Was he already called here? Governor McBride, are you here?
I think Governor Dresden was one of the ones that was not present the first time. I don't know if he's here.
Governor Dresden, are you here? Oh, there you are.
I'm here. I can't hear very well.
Okay, well, can you hear better now?
Oh, yes, that's much better. I don't know what happened. I'm here.
Governor Sayani, are you here? Governor McBride, are you here? We have 9 governors, so we have quorum. So I believe the next person up is Governor Williams-Ruth.
Thank you, Mr. President. I'm going to start by moving for the adoption of, as to answer question number 3, for the adoption of the concept of Paul as set forth in the proposal I had previously submitted.
Is there a second?
All right, well, I will then just ask that the notes reflect that this was the end of the Paul proposal and that it is no longer a valid option for moving forward.
Thank you very much. During the lunch hour, I did get a motion from Governor Abell.
Mr. President.
Governor Stevens.
I have a real question, which was, you know, I'd asked before if we were going to get a presentation. So I'm curious. I mean, Governor Williams, you can do what you want, but we had not gotten a presentation nor a discussion today. So I don't know if you were looking to actually have that be the response, but since we hadn't heard from you and we hadn't had a discussion, that may be a part of why you haven't gotten a second. But that's just my comment. Thank you.
May I respond, Mr. President?
Yes, please.
Thank you. Every member of the board received an email from me this week, and I would disagree, Governor Stevens. I did give a presentation. I spent significant amount of time at our July meeting. In fact, I received a lot of criticism that I was monopolizing the time with my proposal. And so I have, and taking the numbering and doing the whip count, for lack of a better term, it was my understanding that there was not support for my proposal, which, though I believe it to be the best one, is not shared by others. And the fact that not one person was even willing to put it up for a vote after knowing what we've already discussed. So we are at 1 o'clock. We haven't taken a single vote. Today's the day. We've got 6 new governors coming in after September. And I did not want to monopolize anyone's time for a proposal that no one really wanted to see advance. So that is why I did what I did.
That answer your question, Governor Stevens?
Oh, sure, fine.
Thank you. I think this was sent to you, Executive Director Nevitt. Maybe you could read it.
Sorry, I had to pull it up. Thanks for your patience. The motion is that the Board of Governors answer question number 3 as follows. The ideal structure of the WSBA is a reformed structure that transitions the regulatory functions under the Washington Supreme Court and transitions professional trade association functions to a new voluntary entity to be created.
Is there a second to that motion?
I'll second.
So now we have time for discussion. I have a couple of hands up already. I don't know if they want to speak to the motion or not. Governor,
Mr. President, this is Governor Abel. Can you hear me, sir?
would you like to speak to your motion?
Well, I may, and I want to apologize to the chair and to the board. I'm in a spot with kind of spotty cell phone coverage. I believe I should be good from here on out. I believe my presentation earlier today supports the motion. I would ask that it be adopted, and I thank the second. Thank you, Mr. President.
Thank you. Governor Lefebvre, do you want to talk about this here proposal? Well, then we're up to Governor Couch, followed by Governor President-elect Clark.
I'm sorry, Mr. President, I was on mute.
Oh, well, let me repeat my question. Did you want to talk about that proposal that's been before
Yes.
the voting?
I
Okay.
would. At the ETHOS meeting in May, we had representatives from California and Nebraska who discussed the experience they had in their bifurcation of their bars. California has an interesting backstory. It bifurcated because there was a legislative reaction to profound dysfunction at the bar. There was a series of scandals and lawsuits over the executive director siphoning off money, which ended up having the Chief Justice be deposed, while the Los Angeles Daily News reported that the bar had allowed hundreds of complaints of unauthorized practice of law to sit in drawers for months with no investigation. I don't think that's anything like where we are. In Nebraska, it was ordered by the Supreme Court in anticipation of the constitutional issues and they wanted to avoid. Interestingly enough, the representatives from both California and Nebraska said that after bifurcation, the benefits and services to members were truncated. And the combined cost of the voluntary and mandatory bar increased. None of the representatives said that bifurcation was a good thing. Now, the objections we have to our current structure, and which are to be addressed by bifurcation, are basically three. The first one, Seattle centric. This is a little, perhaps not so much. I'm sorry. Let me go back. We're Seattle centric. California has half a dozen standard metropolitan statistical areas with over 1 million people. We have one. California, their state capital, is in the middle of those areas. The bulk of, I would be interested to see a breakdown of where our members live, but I do note that we've doubled representation of the 7th district. And I would bet a majority of lawyers in Washington live in the 7th and 9th districts. We're Seattle centric because that's where the lawyers are. To address that, we should have outreach efforts. Bifurcation is not going to change that. The second issue is money. We charge too much. What we found is that fees to a new mandatory bar would go down, but not very much. The letters we get in the bar news or comments we receive have this thought that mandatory fees would be like $50 a year. That's just not reality. Finally, we have the freedom of association issue of these folks being forced to be in a group where their personal views don't agree. 3 points here. One, those positions are taken by their elected representatives. Now, I understand that our elections for the Board of Governors are perhaps not so representative. On the other hand, if the disaffected are truly upset, they can run for the bog. They probably win. Two, bifurcation doesn't solve that problem. Many of the divisive issues would remain on the regulatory side. And our Supreme Court isn't going to change focus on diversity, equity, and inclusion anytime soon. If there is a legislative issue, if the federal Supreme Court were to address on that basis, I think Governor Ruth Williams' proposal would be very handy to have as an answer to question number 2. But lacking a need to do so, I don't think we need to do that now. Thank you, Mr. President.
Thank you. We got Governor Couch, followed by Governor President-elect Clark, followed by Practice and Law Board Chair Michael Cherry, followed by Governor Williams-Ruth.
Thank you very much. I'm going to try to be brief, but I want to kind of go over a lot of the things that came up in the last conversation, starting with this idea Governor Abel brought up that based on the membership study, it's what he called a statistical tie, but calling it a statistical tie is a statistical fallacy. As easily as the numbers could be close with the margin of error, the numbers could be 50 to 38 and farther off. We had 2 surveys independently done, one of them by a company we hired, that shows that, the majority of our members want to be part of this. And I thought a lot about Council Indy's point on the 38% and what's fair to those 38% that don't want to be part of this. And it brought me back to studying Hobbes and Locke and Rousseau and the foundations of political science, and the idea of a society beginning with a group deciding and agreeing to join a community together. And, that's how it works. 49% of the people in this country don't wish to be governed by Joe Biden. Is it unfair to them that they are? Or have they agreed to be part of this system? All 38% of the people who voted to bifurcate became a lawyer in Washington, agreeing to be part of a unified bar association. So while it's not the ideal for those people, is it fair? I think so. And we talked about this survey, but I don't want to forget that there was also an employee survey done, which showed, again, a larger group of the employees of the state bar favoring the status quo as it is right now. And I don't want to disregard the feelings of those people, because we are also the board of a mid-sized corporation. Turning to the constitutional issue, this idea that it would be resolved, I won't pretend to know more about this than Council Shankland or Indy. And I agree that bifurcating would add us some protection, but I don't want us to be lulled into the idea that bifurcation will solve the problems and prevent lawsuits. The Texas lawsuit showed us that doing any DEI work will open you up to lawsuits. What Director Platsche talked about is that is the work that gets us to complaints. That's the stuff that's concerned. And bifurcating may add a level of protection, but it won't prevent us from getting sued for the work that we believe is germane and important and needs to be done. And I think we can stand by that work and not worry about what may happen in the future. So I go into my notes here. And it was also mentioned by, Council that I thought was interesting that we hadn't talked about the public or protecting the public interest. And it's true. I realized I hadn't talked about that. But I also think that progress on helping the public only happens when lawyers work together and recognize that they have to work together to serve the public, and that what's in their best interest is also in the best interest of the public. California, the example there, shows us a lot. Now, I'll admit that there is definitely a tension between serving the lawyers and serving the public, but we can look at what happened in California recently, where the regulatory agency decided they wanted to work on this new proposal to serve access to justice. And they had put a lot of effort into this idea, and then it was completely shut down because the Voluntary Bar Association spoke out against it and fought hard against it. Without the buy-in of the lawyers, you won't get progress on access to justice. You won't get progress on serving the public, even if you are bifurcated. California has shown that. And while there is a tension between serving the public and serving the members, I don't think that means we should throw up our hands and say, you're right, and lawyers are inherently incapable of serving the public. I don't believe that we are. I don't believe that we are incapable of serving the public. I think I took this position, and many of you heard me rant before I had this position about the public and how to keep them in mind. And I think we as a bar need to strive to continue to prove that we as lawyers care about serving the public and are well suited to do so. It was brought up in California that there was also this increased mission focus. And that was said by them, but that's something of a tautology. When you cut the mission in half and only do half of it, then obviously you have more focus on that half of the mission because that's all you're doing. You've cut away half your mission. But the real question is, are they getting better results for that? And I just talked about the Access to Justice initiative that was meant to serve the public, to help that on the regulatory function, that was shut down by the Voluntary Bar Association. But in addition to that, it hasn't solved California's disciplinary problems. They had a recent audit report that's making national news that says, and this was an audit report from 2022, years after the bifurcation happened. This most recent audit found that the bar too often resolves allegations of lawyer misconduct behind closed doors and does not consistently address conflicts of interest of lawyers who come under investigation. And bar leaders have had to come out and say that they also have to continue to address racial disparities in attorney discipline, as well as the perception that the bar is reluctant to pursue disciplinary charges against lawyers at large law firms. Bifurcation hasn't solved that problem. And so the question we have to ask ourselves is, they may have gotten increased mission focus because they only have one mission now, but are they getting results from that? And the evidence so far seems to indicate that they're not. Governor Abel asked us to look at California and Nebraska as models of hope, but I don't think that's what they are. In the article that Governor Abel presented us, Nebraska's executive director of the Bar Association was asked if she would recommend the Nebraska approach for other states. And her quote was, and she was asked, would you recommend this? Is the question we're asking right now, Nebraska, would you recommend this for us? And her quote in that article was, I think we have done the best we can with this model. We have really tried to make it work. That's not a hopeful statement. That's not someone saying this is better, everything is going really well. This is someone saying I was forced into this and we're struggling and we're trying to make it work. And California is no different. It's not a hopeful tale, it's a cautionary tale. Membership is down, costs are up, DEI work is scaled back, and the regulatory functions are still struggling. These are not tales of hope in Nebraska, in California. These are tales of caution that we should look at and say, why would we inflict this upon ourselves? Why would we do this to ourselves? Bifurcation at the end of the day is, and as Governor Abel has presented this, it's a theory that this will improve things, that it might reduce fees, that it might improve engagement, that it might improve mission focus. In answers to questions, there were lots of mights and maybes. And I believe Governor Abel referred to it as conjecture at some point. But the problem is right now, this is a theory without any data to back it up. And I understand there's not a lot of data, but the data we have doesn't provide a lot of hope. And worse than just being that, this is a theory that requires a lot of time consuming, a lot of time and a lot of money to implement, to test this theory for ourselves. And the concern I have is if we test out bifurcation, if we spend all that time, all that money, all that effort into the idea of bifurcation on a theory that it might help things, it's even harder to roll that back once we've started that process. It's okay to explore this idea as they've done before, but we haven't seen the data yet that this is going to help us. And if we test this theory and we're wrong, if 5 years down the road we decide bifurcation actually hasn't helped with regulation, hasn't decreased costs, hasn't increased member engagement, it's actually decreased and harmed those things, rolling back that is so much harder to do. Rolling back that is not the same as destroying something. Destroying something is easy. Rebuilding something is much harder. So before we take a vote, I'd ask you to consider that. I'd ask you to vote no on this. Thank you.
Thank you, Governor Couch. Governor President-elect Clark. Okay, Governor Clark has a motion to amend. I offer as a friendly amendment, given the very close divided survey results of the small sample size of our members. I would like to move that we take an advisory vote of the entire active membership regarding the structure of Washington State Bar Association. I believe this is reasonable to ensure that we give every member a chance at input on this important issue impacting the Bar Association, and that the additional information would be of paramount importance for the Board of Governors in making this decision. To that end, I would like also move that we amend the current motion and table making a decision on questions 2 and 3 until after we have the results of the active Washington State Bar Association membership advisory vote on the structure of our organization. I'd envision we hopefully have these results before September 22nd and 23rd Board of Governors meeting, and that we hold a final decision on questions 2 and 3 then. I think we should give our members the chance to have an advisory vote on this issue. Thank you. That's really 2 motions. So why don't we take them one at a time? Anybody want to second Governor Clark's first motion to amend?
I'll second.
So now we have to have discussion on the motion to amend. Governor Williams-Ruth.
Thank you, Mr. President. So I still have my hand up for the underlying motion, but to speak to the amendment, I oppose this entirely. The survey, first of all, I think if we're going to survey the entire membership, it shouldn't just be active. I mean, anyone who's paying us dues should be part of that process if it passes. But I also want to point out that the membership survey doesn't address the legal risk. I mean, the fact of the matter is that I don't care what a survey says. I don't. And if people want to come and nail me to a wall for it, great. People do not understand Keller, Lathrop, GR12. I will be honest, I don't even, if we were to do a survey that says, without looking it up, do you know what GR 12.2 is? The vast majority of people who are not on the executive committee of any section will likely be like, something to do with Tony the Tiger. It's great because people don't operate in this level. So to truly believe that the membership as a whole has I give it to Nancy, give it to everybody, Michael Cherry, to everyone who comes to our meetings that know how the system works, but to ask the membership for a survey when there's so much intricacies into these decisions and discussions. I mean, look at just what the discussions we've had this morning. And then second, we are running out of time. And again, I am terrified, and I will lead the effort if we don't have an approved report by the end of the September meeting. you're going to ask 5 new individuals who have had varying levels from attending some of these meetings to attending none of them to immediately place a vote on this subject that we've been working on since November? No, I oppose further delay. I oppose sending out a membership survey to everyone. You know, again, this could have been brought up when the Membership Engagement Council was doing the survey. The option was there. It was discussed as to whether or not it would go to everyone or just the statistical sampling. And against my opposition, it went just to the statistical sampling. And that's the way it is. So I believe that this is an undue delay in coming to finalization that needs to happen before the end of this term. Thank you.
Thank you. Governor, well, let me start with this. I just want to make sure that people who have their hands up really want to talk about the motion to amend, like Governor Williams-Ruth did. Chair Cherry, are you talking about the motion to amend?
No,
How
but
about,
but the other motion, Governor Abel's motion.
okay, how about you, former President Shichetti? Nope. How about you, Governor-elect Fay?
Yes.
Okay. You're up.
We had this discussion a few meetings ago. Taking a poll of the membership as a whole is not going to give you good information, because the people who are going to vote are people who are invested. You're going to get a lot of complaints when you ask for complaints. We have done a statistically relevant survey designed to get around that problem. And we have the results of that survey. A member-wide referendum is not going to give you representation of what our members think. They're going to be a representation of how upset the individual members are. And that's not relevant information. Thank you, Mr. President.
Thank you. Okay, so now I've got some more people who want to speak to the motion to amend. Former Governor, past President Shichetti.
Thank you, President Collison. Not so much to the motion itself, but the process. And this would also was what I was going to say originally, but it does apply to this as well. When I set up the ETHOS agendas, I called it Examining the Historical Organization and Structure of the Bar. And I didn't make it into a task force. I didn't make it into a committee. It wasn't a subset. It was us all getting around and talking about this issue and deciding what was in the best interest of the organization. I envisioned that we would be voting on this at a formal Board of Governors meeting as a Board of Governors. And I think others had that same feeling. That said, there's no rules here that says we have to limit this to just the sitting Board of Governors. That was never in the charter. And I've said this before, we have 3 incoming governors who have sat through most of these meetings. No, 3 of them sat through most of these meetings that have learned about this process, that have participated, as Governor Fay has been doing today, and others who have a deep interest and opinions about this. And I see no reason why we should be excluding these folks who are going to be members of the Board of Governors within a month and a half's time from considering and being involved in this discussion. In my opinion, there's no good reason for that. It's not necessarily a Board of Governors vote, but it makes all the sense in the world to me that we have elected folks who have things to say and contribute, and they should have that voice. Thank you.
Governor Williams-Ruth speaking to the motion to amend.
Yes, I'm sorry, I can't not respond to that because I was there. I was part of the coalition that got this approved And it absolutely was the discussion at the Silver Cloud in Ruston about the need to have this done by the end of this term. Because if ultimately it's not, then we have all these hours that were spent in by the people who are going to be cycling off, losing their vote. So they have just contributed 100 hours of meetings on weekends. So that was the intent. The intent was this last meeting was to happen in August with the approval of the report to go to the court in September. And I find it so disingenuous to say that that's not what we had talked about in that room, because it is. And I feel it's wholly disrespectful to every governor that's going to be cycling off and losing their vote. So President-elect Clark won't get a vote. I will continue to move over to a different vote, but the 8th district person that's going to come on new, not get a vote, or not have any concept or clue. The 3rd district, or 4th, whatever President-elect Clark is. And then, I'm sorry, so Governor-elect Fay has been here, and so has Kerry, and Nam has been at some, but not all, not from the beginning when we started this, as they were governors-elect in the springtime. So I really just feel that this is a complete bastardization of what the schedule was that was approved, and truly an unnecessary delay.
Let's see. We've got our former president Shichetti.
Just to clarify, I understand that Governor Williams Ruth's intent for bringing the motion to have it settled in August was his intent. That was not my intent at the time. I don't get a vote, but that was not my intent. It was my intent that we have this at a Board of Governors. Setting that aside, I'm not suggesting necessarily that we do that. You guys can decide that. You have the power. I'm suggesting that today, if you're having a vote, you should include Governors Fay, Governors Petrasic, and Governors Nguyen. That should happen today, as well as the governors from District 5, District 4, and District 8.
Let's see, who else wants to speak to the motion to amend? We got Nancy Hawkins. Were you planning on speaking to the motion to amend?
Of course.
Okay.
I'll be brief.
Thank you.
I'll just remind that sections, our family law section in particular, when this process started, expressed a very strong preference that sections be at the table for this discussion and decision. And we were told no, that this was a decision to be made by the Board of Governors, and sections would not have a vote. So it is, if this whole thing is going to go back to some other structure for deciding the recommendation, sections should get a vote too. And oh wait, sections have voted. They voted with their comments. And I'm always somewhat struck, and I'm particularly struck in this discussion today, that there's a lot of talk about member engagement and how important it is to hear what the members have to say and to take that into account. But this committee has heard from members. It's heard from a lot of members through the comments from a number of sections who have said they are not in favor of bifurcation. They are in favor of maintaining the existing structure. And that should be given far more weight than hearing, as I think it was Brent that said, the people that have not studied this issue would make comments based really on their complaints with other aspects of their complaint with the organization. It's too Seattle-centric, although we don't have any clue what that really means. And it's demeaning to Eastern Washington in general. I think that in addition to ignoring the prior testimony of sections, we heard today that some comments that would indicate that it's less than valuable or even harassment or monopolizing for members of the public, as sections are referred to come and make comments today. And I would ask that those kind of comments not continue. And that, in fact, those of us that are here today from sections, over and above a number of, a number of the governors that did not make the time to be here today for whatever reason, we're here. We should be treated with respect when we make comments. So I would urge that there not be some expensive delaying tactic to survey members as proposed by this motion. Thank you.
Thank you. I think we have Governor Bell followed by Governor Higginson, and then I think we're back to Governor Williams-Ruth.
Thank you, Mr. President. I was going to speak briefly in favor of this motion to amend. First of all, I share Governor Williams-Ruth's concerns about delay. Obviously, we do not want delay. We need to get this done as soon as possible. That said, if this were to succeed and pass, I did include a recommendation that we have an advisory vote in my memo that was submitted to the board as part of the late materials. I had envisioned it coming after today's vote on what will hopefully be the substantive proposals in front of the board about status quo or a reform proposal. But I do think an advisory vote would be a good idea. I believe we could conduct it in a timely fashion. So those are my comments. I had intended to call the question, but I understand there's at least a couple of people after me. But it's my hope that we can vote soon on this motion to amend and fairly soon thereafter vote on the underlying motion. Thank you, Mr. President.
Thank you. Hope you can stay on the line. Governor Higginson.
I would like to vote on this before I leave the board. I think that I have sat through just about all of these meetings and have a lot more to share in terms of my background, for example, than people who are just joining the board. That said, that shouldn't be what I want is not necessarily what should happen. However, I do think we should be voting, and I like the notion of voting today, but then sending it out to the members as an advisory to get their advisory vote before we make our report to the court. So I feel like we could accomplish both. We can have our vote today, and we'll either vote to bifurcate or we won't, and then we can send out an advisory ballot. And it's not a survey, it's actually an advisory ballot, which I feel will get more response than a random survey to people, and see what the members have to say. I continue to be troubled by the notion that we don't really care what our members think. And with all due respect to Ms. Hawkins, I'm a member of the family law section, I'm a member of the solo and small practice section, and we members of those sections were not asked what we thought. The executive committee met at a time that was not announced to anybody and made their own decision. That's not good representative government, and frankly doesn't represent what I think as a member of those sections, and I suspect other people as well. I do also want to point out in support of taking an advisory vote that we have 29 sections. There's private sections, if you will, too, like domestic relations attorneys of Washington. Of those 29 sections, I think I want to say maybe I think it was less than 6 formally commented. The elder law section and the health law section chose not to comment one way or the other. So we can't draw any conclusion from that. We can't infer that they like the status quo or that they don't like the status quo based on their executive committee planning to take a position. And I also do want to remind everybody that DRAW, which has over 600 members, was very strong in its letter to us saying that we have such an inherent conflict of interest that we can't fairly represent the members and the public at the same time. And they went into detail about why. That's over 600 of our colleagues who had that feeling. So this tells me that an advisory vote would be an excellent idea. I myself really do want to hear from my colleagues in this profession as to what they have to say. And I think it's rather elitist for us to say, oh, we don't need to ask those people. We know what's best. They trust us. Well, do they? I don't know if they do or not. We don't trust each other. So I don't know how we could think that our members trust us any more than that. So I'm speaking in favor of the motion, but I do not think that it precludes us taking a vote today. And to the extent that it would, I'd want to amend that, but I need to take another look at the wording to see what happens. So I'd like to, in sum, support the motion to send out an advisory ballot to all of the members and also take a vote today, yay or nay about bifurcation. Thank you.
Before we get going further, I would like to ask the executive director, are you there somewhere?
I'm here.
Oh, there you are. Have we gotten sufficient response for a quorum for a meeting later this month? The ETHOS project or no?
We have not yet. However, we think we can float some Saturday dates and that may get us there, but no, we have not yet.
Just wanted everybody to know that right now, as things stand, we don't have any more ETHOS meetings scheduled because we can't get enough of the governors to be available, which is understandable. As we all know, living here in the Northwest, August is the one decent month of the year without a lot of rain. And before kids have to go back to school and all that fall fun stuff happens. This is nothing new. It's been going on since I've been born. So, so with that in mind, I want you all to know that we don't have another meeting scheduled. So that means we don't do something today, then we're talking about September, late September at the fall meeting. And if something goes sideways between now and the fall September meeting, like people are sick, can't go, don't want to go, we got problems, folks. Just want you to realize that and think about that when you're making these decisions. Okay, I've got some other people that wanted to speak to the motion to amend here at 1:43 in the afternoon. Is it Governor Abell? Did you already speak on the motion to amend?
I already spoke on it, Mr. President. I apologize. I'll lower my hand.
Okay, Governor Higginson, Governor Williams-Ruth, Governor Couch, or what I see, and then maybe Governor Adwale.
I've lowered my hand, Mr. President. Thank you.
Governor Williams-Ruth, Governor Couch.
Mr. President, I'm ready to speak when it's my turn.
Okay, thanks. You're on number 3 in line as far as I can tell on the motion to amend. Governor Williams-Ruth, did you have something else to share?
No, this hand is for the underlying motion.
Okay, thank you. Governor Couch, are you on the underlying or on the motion to amend?
On the motion to amend, I just want to briefly mention, it was addressed by Governor Higginson about the sole and small practice section. That was inaccurate. I am on that section. It's the executive committee. We sent out emails to our membership, solicited feedback. Based on the feedback we got, had meetings on this that were open, public, everyone knew it was happening, and made a decision based on that at the time with feedback from all the members on that. As far as the advisory vote, it's interesting to me that we have the same people who before are saying that we need to get a membership, like a vote from the membership, are now saying, well, we got their decision and we're ignoring it. We had a professional company do a survey that they told us would give us a statistically accurate sampling of what the actual membership thinks in the best way possible, better than doing an advisory vote. And now we're ignoring that and saying, well, we need to hear from the members while ignoring what the members have told us. I think it delays time. I think it wastes time. I think it's unnecessary. I think we've reached the point where we need to make a decision and not continue moving the goalposts because we don't like the results we're getting. Thank you.
Okay, I think we're up to Governor Adewale. Governor Adewale, can you hear us?
Thank you, Mr. President. Thank you, Mr. President. I'm just pulling over to park so that I don't talk while I'm okay. Thank you, Mr. President. I'm not going to take too much time, and I don't know where the motions are or where things are, but I wanted to be able to make my comment before we vote on anything. So this comment might be related to this motion. It might not be necessarily related to this motion. But I just wanted to say one thing because I couldn't respond to Chief Andy at the last time before we went to lunch. And I also wanted to respond a little bit to President-elect Untitled comment earlier today with regards to Eastern Washington, okay? When we came to, and I'm going to start with that first, we had an opportunity to have people make comments in Spokane when we had a meeting in Spokane. And the Spokane County Bar Association, one of the issues that their members raised is the fact that when we bifurcate and we have a voluntary bar that starts competing with regional bars, we are going to lose the uniqueness of our local bar and the opportunity for us to be able to advocate on local issues is going to be gone because all these sections are going to come into our neighborhood and take over the regional nature of our bar. We're going to lose that particular importance that this regional bar provided to us. So that's one of their fears. And they believe that bifurcation is not good for us in Eastern Washington because of that point, that we're going to lose the essence of our bar. And that's one particular point. And I don't know in the world, and I text Governor Williams-Root about it. I don't know in the world how my good friend, President-elect Untitled will bring the issue of the location of the bar into this issue. The location of the headquarters of the bar is an issue, whether we have an integrated bar or we have a voluntary bar. It's an issue that stands on its own. Whether the status quo goes or remains, my goal, and as many other governors have indicated, even those from Seattle, is that downtown Seattle is not the best place to put our bar. So whether we voted yes or no on any of these motions, that is not an issue. And now to make an argument about, taking it to Olympia, it just really out. I can't understand that. So to be serious about this, let me just also answer disciplinary chief and this question, okay? And I'm going to answer it based on a comment by the disciplinary chief or the bar chief of, I think, South or North Dakota at the ABA conference. And this person said this. He said, when anybody raised the kind of argument that Chief Andy raised, ask them, who will you rather provide discipline for your members? The member to discipline themselves or the governor? There are people from my district that do not agree with this current governor. If this current governor gets to choose, because what you are voting for, if you bifurcate, you are essentially saying that the current act doesn't work and the legislators would have to have a say in it. We have to go back to the drawing board, whether you like it or not. That is eventually where this is going to go. Would you rather have our bar association appoint people that will be in charge of discipline, or do you want the governor Do you want the governor or somebody outside of the bar? None of our justices are members of our bar. A self-regulated profession, as we have, is the best for our future. Not to have somebody outside of our bar regulating us. That's just the way it is. That's just the consensus from the meeting that I had at the conference, at the ABA conference, from all the bar associations. It is better. They said it's really terrible, the experiences that people were going through in those other states where the power to discipline and the power to admit people to the bar and the power to control the professions is in the hand of political leaders. I just don't want to see the day. I've had enough problem with the left and the right, even in my local government area, that I don't want to have to deal with political people appointing who is going to control the bar association. That is where we are going to go with this issue. That is the venture. Whether you like it or not, you can say no. But that is what happened that is what almost happened in Texas. That is what happened in South Dakota or North Dakota. So I just wanted to say that bifurcation is a pathway to asking the control of the bar to be taken out of the hand of lawyers and to be put in the hand of political leaders. That I cannot stand. So, you can disagree with me with regards to my position. I doubt if I'm wrong, but if I'm wrong, I'm willing to listen to you. But please trust me when I tell you that this is the consensus from what we gathered from the conference, that when you do this, when you open yourself up like this, when you take the power to control your profession out of your own hand and you put it in the hand of those people who are not members of your profession, you are endangering the professionalism of the bar. That's just my comment. Thank you, everyone. I've been listening to very informed arguments from both sides. Thank you.
Thank you, Governor Dwale. Anybody else want to speak to the motion to amend? Governor Higgins.
Mr. President, Dan Clark's asked me to indicate that he would like to withdraw his motion, which I know is an informal process, but he's indicated he'd like to do that. And as I was the second, I would agree to withdraw if that would be acceptable to everyone.
Any objection? Okay, I believe the motion has been withdrawn. Or do we have to vote on that? Where's Governor? Where's my parliamentarian?
Mr. President, can I call a question?
Hold on.
Because this was before the board, if there is no objection to withdrawal of the motion, that is sufficient and you don't have to have a roll call vote.
Okay. Anybody object to withdrawal of the motion? Don't see any hands up. Okay. I presume, Governor, President-elect Clark, you're talking about both of them, right?
Yes.
Okay. Okay, so we have some people who want to speak to the original motion. I think we have Chair Michael Cherry. Yes?
Yes, thank you, President.
Followed by Governor Williams-Ruth, followed by Governor Dwale, followed by Governor Bell, followed by Governor Couch. That's the lineup.
So in the motion of President-elect Abel, would somebody please clarify for me, we're talking about moving the regulatory functions. And my specific question would be, is the practice of law board a regulatory function? I really appreciate if somebody could enumerate for me what the regulatory functions that we're talking about moving are. Thank you.
Anybody care to address that?
I can answer that, Mr. President.
Go for it.
Under the proposal that Governor Bell has put forth, and I reviewed it with him, the current 6 boards and councils of the Supreme Court would be unaffected by, their existence would be unaffected by bifurcation. They are a court-created group of boards and councils. The court will continue to do as the court wishes with those, and presumably would keep them in effect, but that's up to the court. They would not, the funding would have to shift back to the court, but other than that, they would continue to exist.
But that would say that we did not get administrative support from an entity called a bar association. We would get all of our support from the court.
That would be, yes, I assume so. They're court creatures. The court would take care of that. But it's my opinion, and my considered opinion, that if the court takes that, if we bifurcated and those councils and boards are now entirely handled by the court as the court wishes, that would be part of the court's budget request to the legislature. And we all know that the judiciary, but constitutionally, is supposed to be supported by the legislature. So I don't think that's insurmountable.
Any follow-up question? Chair Michael Cherry.
I think this is an important point, and that wasn't quite the answer I anticipated. I anticipated that they would be a regulatory function and that they would get some regulatory funding from members of the bar association. So I think I'm a little confused at this point and unclear. Thank you.
Thank you. We have Governor Williams-Ruth, followed by Governor Bell, followed by Governor Couch, followed by Governor Higginson.
Thank you, Mr. President. So this wasn't my first idea for a resolution of this process, but it is going to address the issue that I have, which again has not been addressed by those who want to maintain the status quo, and that is that we have a broken system with rules that are not being enforced relating to the legislative component. But I've written down specific comments in response. So first and foremost, APR 1 and ELC 2.1 specifically already make the admissions and disciplinary system that of the Supreme Court. So we already are, I really found the comments from Governor Boyd to be confusing to me, as she's referencing being an Eastern Washington or an Eastern Oregon person and didn't want the government telling her what to do. But for me, in my mindset of, it's like getting your tabs in Washington. You have to pay the actual mandatory fee, but then they say, would you like a discovery pass for $30? It'll give you the option to go to any state park anytime you want. That's a bifurcated system of the bar. The unified mandatory is everyone gets their tabs and a discovery pass, whether you like the nature or not. And so the fact that there was concern about, being controlled by the government and having them tell, they already, the rules already established. APR 1, the Supreme Court is in control of admissions. Number 2, the fact that we have confusion amongst our legislators, and I'm going to go with confusion rather than deliberate intent to violate our section comment policy, tells me that, and the fact that we have not, we as an organization have known it's existing and are not doing anything to stop it, tells me that maintaining the status quo is not going to fix it either. I also, in my first year in service, where the chair of the board legislative committee used the GR12 analysis as a weapon for the policies and rules that weren't the desired policies and rules for supporting. Oh no, the GR12 was not sufficient. But then we go to something equally as not specifically tied to court rules or regulating the bar, and it was something that they liked, and oh yeah, GR12 is okay. And that's a problem for me, That's, I mean, you know, the fact that other people have talked about East, West, and I don't care. I have no problems with what we're doing other than the fact that we have a problem. And even if we haven't drawn a lawsuit yet, I am a governor in this organization, and I'm sitting in this room and we're turning a blind eye to the fact that things are not being done right. I equivocate that as to us being on the board of Boeing and the head of the Wichita, Kansas facility dumping stuff out in the back pond. The board of directors is responsible for the actions of that factory. And we are not doing anything, and it drives me insane. And I've mentioned it, I've said it, I've raised the flag, and no one cares enough to do anything. And so that's where this option of bifurcating will, you know, it'll put everything in a voluntary organization, because I also don't believe people should be compelled to have, I mean, I want to have a full-throated, you know, robust discussion about politics, because lawyers are subject matter experts. They're the ones who have to work in the machinations of the application of the statutes. But the parameters set up in the rules by GR 12.2, the bumpers that say what we can do, says that's not our role as the WSBA. I want that to change. And I want it in an organization that's not constricted based on the area of law you practice, such as WAPA or WIDL or the Washington Association of Justice, or anything that's county specific. I want there to be an umbrella organization where anyone who just happens to be a licensed member of the state bar can help get in there and speak and advocate for political issues. So I want there to be more. And we just can't do it. So even if we get a unified mandatory status quo bar to crack down, and all we talk about is changes to the Bar Act, changes to court rules, changes to the administration and funding of the courts, I don't want that. I want the lawyers of Washington. And who is out there advocating for the uniform easement law? Who's out there advocating for cannabis law? I mean, we need to have an organization in this state that is in there helping the legislature. You know, I don't, and I just, the idea of, oh, well, you know, we can just wink and nod. Great. So the people in power are the ones that get to control whether we let something through or not, rather than an actual process that's open and transparent. And so, you know, that is why I will be supporting the motion to bifurcate, because at least with a bifurcated system, people will have the opportunity to truly engage. I mean, you have people in this organization that have been involved in the legislative process almost their entire professional career, but yet they're constrained by what officially they can talk about and help, you know, advance laws, because we have a narrow lane, as we should as a compelled organization. I want there to be a place where that person can go and really unload all of their bookish knowledge on the most random laws that still impact 1% of Washington residents. And there is no organization that is out there helping the legislature change the laws. Just this last week, another person came to me asking about the Uniform Fiduciary Access to Digital Assets Act, a law that was passed that's horrible because there's no teeth that can compel anyone to comply with the law. I tried to change it on my own. I got bipartisan support straight to the House floor. Maybe if I'd had a bar association behind me that was rallying for this, that had this bipartisan support, we could have overcome the lobbyists on the other side that were saying, no, don't put this extra pressure on the tech industry. No. That would cost us money, because we'd actually have to invest in the people who have died and how do people get access to their information. So, you know, I would rather be a unified mandatory organization that splits off the political. But since that option is not available, I vote for bifurcation. Thank you for listening.
Thank you, Governor Williams-Ruth. Okay, on my list, I've got Governor Adewale, but I don't see that he's on. Oh, there he is. You were in the queue. Did you decide not to be in the queue, Governor Dwally?
Mr. President, I call for vote.
Are you calling the question? Is that what you're doing?
I call the question, sorry. I'm sorry. Calling the question on this bifurcation issue.
Requires a second, no debate. We have a second.
Seconded.
Okay, so that requires a 2/3 affirmative vote. We'll go down the list. Governor Bell. I see.
This is the vote on the underlying motion, Mr. President, my motion.
No, this is a
Or is it the
call
vote to call the-
on the debate. On your underlying
I see.
motion.
Aye.
Okay. Governor Adwale.
Aye.
Governor Angelville.
Aye.
Governor Boyd.
Aye.
Governor Clark.
Aye.
Governor Couch.
Aye.
Governor Dresden.
Aye.
Governor Higginson.
Aye.
Governor McBride. Governor Peterson. Governor Pertzer.
Aye.
Governor Theani.
Aye.
Welcome, Governor Theani. Governor Stevens.
Aye.
Governor Williams-Ruth.
Aye.
It's unanimous. Well, you have everybody who voted yes. 2 didn't vote. Is that what you have, Executive Director Nevitt?
Yes.
All right, so we're going to vote on Governor Abell's motion. Would you like me to read it again? Or can we have the Executive Director rules?
Yes, please, Mr. President.
So, Executive Director Nevitt, can you read it, please?
Yes. The motion is that the Board of Governors answer question number 3 as follows. The ideal structure of the WSBA is a reformed structure that transitions the regulatory functions under the Washington Supreme Court and transitions professional trade association functions to a new voluntary entity to be created.
Everybody have the motion in mind? Ready to vote? Okay. Governor Abell.
Aye.
Governor Adwale.
Nay.
Governor Angelville.
Nay.
Governor Boyd.
No.
Governor Clark.
Aye.
Governor Couch.
Nay.
Governor Higginson. Oh, excuse me,
Aye.
Governor Dresden. Sorry, I missed Governor Dresden.
I vote no.
Governor Higginson.
Aye.
Governor McBride. Governor Peterson. Governor Pertzer.
No.
Governor Sayani.
Nay.
Governor Stevens.
No.
Governor Williams-Ruth.
Aye.
So I have 4 yeses, 8 nos. Is that what you have, Executive Director?
Yes.
Oh, and 2 not voting. Okay,
Mr.
so
President, this is Governor Abell. This is Governor Abell. May I be recognized briefly, sir?
yeah, I just want to announce for the record that the motion did not carry. Go right ahead.
Thank you, Mr. President. Mr. President, I wanted to say briefly to this board how proud of this board I am and every member in it. And the reason I say that is because I think today's discussion has been really robust and helpful. I think it was very ably presented, particularly by Governors Couch and Boyd. I think we can go back to the court and our members and show that we've really had a full-fledged discussion on this. I appreciate the time and the attention that everyone gave to my motion. Thank you, Mr. President.
Now we have Governor Couch has a hand up. I believe he has a motion about it.
Yes, at this point in time, I would like to make a motion that we recommend as an answer, or that we answer question 3 by saying that we should work to preserve the current unified structure of the bar.
I second the motion.
Okay, Governor Couch, you want to speak to the motion?
I think I've done plenty of that today. Thank you.
Governor Adewale is the second. Would you like to speak to the motion?
The motion speaks for itself. Thank you, Mr. President.
Anybody else would like to speak to the motion? Not seeing. Oh, got one hand. Governor Stevens.
Yes, Mr. President, I think we have turned this almost to glue. I move the previous question. I call the question.
Requires a second.
I'll second it.
I'll second.
Okay, got a Governor Stevens moved, called the question, seconded by Governor President-elect Clark. And we get the 2/3 vote thing going here. Governor Abell.
Aye.
Governor Adewale.
Aye.
Governor Angelville.
Aye.
Governor Boyd.
Aye.
Governor Clark.
Aye.
Governor Couch.
Aye.
Governor Dresden.
Aye.
Governor Higginson.
No.
Governor McBride. Governor Peterson. Governor Pertzer.
Aye.
Governor Siani.
Aye.
Governor Stevens.
Aye.
Governor Williams Ruth.
No.
Is that a 2/3 vote? According to your count, Executive Director Nevitt, I think it is.
I haven't done the math yet. Council Shakeland, have you done it? I think we have 12 voting.
Got 10 yeses and 2 noes and 2 not voting.
So we need 8 for 2/3, I believe. So then the motion carries.
And that motion carries. Okay. We're going to vote on Governor Couch's motion. Without further ado, Governor Abell. He may have dropped off.
No. Nay.
Oh, is that you, Governor Abell? Oh, there you are. Okay.
That is correct. Yes, I vote no on the underlying motion.
Thank you, Governor Adewale. Governor Adewale?
I vote yes.
Thank you. Governor Angelville.
Yes.
Governor Boyd.
Yes.
Governor Clark.
Aye.
Governor Dresden. Oh,
Yes.
excuse me. I'm sorry, Governor Couch. I'm sorry, I missed you.
Also yes.
Okay, Governor Dresden is a yes.
Still a yes. Still a yes.
Okay. Governor Higginson.
No.
Governor McBride. Governor Peterson. Governor Pertzer.
Aye.
Governor Siani.
Yes.
Governor Stevens.
Aye.
Governor Williams Ruth.
No.
Nine yeses. Three noes and 2 not voting. Is that what you have, Executive Director Nevitt?
Yes.
Motion carries.